Conciliary and appeal in the matter of Mex Group Worldwide Ltd and another, and Cormack and others.
Please the court. My lords, could I start by apologising for the fact that my learned junior doesn't have his wig. I actually have my learned junior's wig and mine is on its way to court, so I'm very sorry.
Yes, I was irresistibly reminded of an occasion when I was very, very junior, appearing in the Maidstone County Court, where the requirement at lunchtime was you drank a pint of beer with the managing clerk of the firm of solicitors who had a pie and chips, and then you brought him a pint of beer. So I was slightly, probably distracted, shall we say, and I went back in the court, didn't have my wig on. My opponent said, just as the judge came in, "Where's your wig?" So I was covered with confusion. And the judge, who was a lovely old judge called Felix Whaley, I said, "I'm terribly sorry, Your Honour, could I possibly go and get my wig from the robing room?" He said, "Oh, we won't wear wigs this afternoon."
My lords, could I just start by explaining the format of my submissions? Contrary to my indication yesterday, I'm actually going to start off where we left off yesterday. I hope that might be helpful, and certainly I hope it won't be unhelpful. And so what I'm proposing to do is to go straight into full and frank disclosure, then to deal with section 25. My learned junior, Mr. Kinman, in accordance with the guidance encouraging greater participation of junior counsel, will deal with risk of dissipation, and then I will come back to good argument case. So, my lords, turning to non-disclosure, my client's position is fully set out in our skeleton argument at paragraph 79 to 130, which I'd invite my lords to consider. Clearly, my lords are very familiar with the relevant principles. We obviously rely on those set out in paragraph 7 of Tugashev, and I don't propose to take the court to those principles at the moment. So, my lords, the first full and frank disclosure point that I'd like to address today concerns the BVI proceedings. My lords were taken to a part of the judgment below, which is to be found in the core bundle, tab 10, page 156.
Yeah.
Paragraph 80 and paragraph 81. So paragraph 80, Judge Tinkler, Mr. Tinkler says, I turn to page 11. At the bottom of that page, Mr. Justice Lavender is told that some adverse findings made against the claimant at an interim stage, and to the extent that those adverse findings were made, they were in effect reversed by the Court of Appeal in the BVI. And the judge goes on to say, this is a very selective description of the BVI proceedings. It was misleading in itself and by omission. The findings were not reversed by the BVI Court of Appeal, as Lavender J was told. One notable feature both of the hearing itself and the skeleton argument is the way in which the BVI litigation is handled. It does not constitute a significant part of either. It was, in my judgment, absolutely central to the explanation of what was going on in the overall picture and the Scottish litigation. It should have been explained to Lavender J much more clearly what the BVI court had and had not decided and why. So first to the Scottish proceedings, because there's a reference there of the judge to the Scottish proceedings. And my lords, if I could ask your lordships to turn to the supplementary bundle, tab 89, page 1739. So this is part of the Scottish pleadings, and it's entitled Conclusions, although it precedes the condescendence. So page 1739, we can see in paragraph 1, reads as follows: for declarator that the defenders have engaged in an unlawful means conspiracy directed inter alia at harming and injuring the interests of the pursuant by causing the 11th defender to seek to renege on the agreement reached in the schedule to the consent order granted by the High Court of Justice of the British Virgin Islands, dated the 14th of December 2020, as defined in the condescendence hereto, which agreement was a lawful, valid, and binding compromise entered into by the parties to it, and for that purpose dot, dot, dot. My lord, self-evidently, if MGWL are going to accuse others of conspiring to renege on a consent order that was, quote, a lawful, valid and binding compromise, it is vitally important to show that to be the case. It's no use alleging that VDHI are bringing a claim in the BVI, falsely alleging that the BVI consent order is a collusive sham and that that is part of a wider conspiracy if the BVI order is in fact a collusive sham and VDHI are right. And my lords, I'd also refer your lordships to the condescendence which follows, and in particular to paragraphs 18 to 22. I think that starts at page 1750.
Yeah.
And one sees the lead up to the settlement, and then at paragraph 21, the pursuer entered into the settlement contained in the consent order in good faith for proper and lawful purposes. So, my lords, forgive me if this is obvious, but it's a necessary part of MGWL's case in Scotland that Mex Clearing and the other parties to the consent order entered into it in good faith. And one can also see, and I won't take your lordships to it, but one can also see how it was presented in the ex parte skeleton argument. And I'll just give your lordships the reference. It's supplementary bundle, tab 91, page 1784, and in particular paragraphs 19.6 to 19.8. And my lords, in the BVI, by the time that MGWL came before Mr. Justice Lavender, ex parte, Mr. Justice Jack had found a good arguable claim in favour of VDHI on the basis that the BVI consent order was a collusive fraud. And my lords, could I suggest, far from me to do so, that if my lords are inclined to do any reading outside of this court, the decision of Mr. Justice Jack, which is in the supplementary bundle, tab 52, page 466, refusing to discharge the freezing order is a good place to start. I should say that we weren't a party to that, but it's a good place to start concerning the goings-on, particularly as regards Mr. Smith and Multibank, around the time when the consent order was entered into. And as I've already mentioned, that judgment was upheld by the BVI Court of Appeal, even after they'd recused Mr. Justice Jack, and the page reference for the Court of Appeal's decision is supplementary bundle, tab 79, page 1350. And my lords, we say it was obviously incumbent on MGWL to explain that Mr. Justice Jack had found that VDHI had a good arguable case, that the consent order was a collusive fraud, that the BVI Court of Appeal had agreed with him, and their reasons for doing so. MGWL failed to do any of this. All it did was say that Mr. Justice Jack had made adverse findings, see the skeleton argument at paragraph 16, page reference, and I won't take your lordships to that at the moment, but page reference 1782, I think that's tab 91 of the supplementary bundle, and also the affidavit of Yahya Tahir, paragraph 90, which is in the supplementary bundle, tab 93, page 1867, and that those findings had in effect been reversed by the BVI Court of Appeal, and one sees that in the transcript, page 11, lines 20 to 24, and the page reference in the bundle is page 1891. And that was inadequate and actively misleading. It did not begin to explain the adverse findings or their bases. The BVI Court of Appeal did not reverse any adverse findings of Mr. Justice Jack. It recused him on the basis of apparent bias, but expressly upheld his conclusion that VDHI had a good arguable case of fraud against Multibank. As regards the finding of apparent bias, the BVI Court of Appeal found that elements of Mr. Justice Jack's judgment might have suggested to a fair-minded and informed observer that he'd formed a concluded view of the merits of the case, including his use of certain phrases, his suggestion that his judgment should be shared with a financial regulator, and his personal research on an earlier case in which Mr. Tahir was found guilty of contempt. And one can see that from the Court of Appeal's decision, and for your lordship's reference, that's it's their decision at paragraphs 49 to 52, page 958. but the judgment concerning good arguable case was upheld. My lord, sadly, the position gets much worse, because not only did MGWL not explain what the upheld judgment of Mr. Justice Jack was about, let alone take Mr. Justice Lavender to the judgment, but they didn't refer to the key documents that led to the findings in that judgment. MGWL was, of course, well aware that there are a number of key documents which are found by Mr. Justice Jack to be cogent evidence that the BVI consent order was in fact the product of fraudulent collusion between Mr. Smith and Multibank. In particular, the transcripts of the meetings between Multibank and Mr. Smith in Dubai, and the page reference for those is Supplementary Bundle, tab 26, page 193, and the indemnity granted to Mr. Smith in advance of the signing of the consent order, page reference Supplementary Bundle, tab 34, page 227. The latter document having been described as an extraordinary document if the compromise about to be embodied in the Tomlin order was a bona fide settlement. That's from Mr. Justice Jack, paragraph 36 of his decision, reference Supplementary Bundle, tab 52, page 495. My lord, in circumstances in which a judge, even one who subsequently recused on the basis of apparent bias, has looked at these documents and found that they were strong evidence that the consent order was a collusive fraud, it was incumbent upon MGWL to take Mr. Justice Lavender to and through those documents. MGWL didn't do so. I don't even think it mentioned their existence. MGWL say, well, we produced these transcripts. You're reading too much into them, and we disclosed them to Mr. Justice Bryan. My lords, 2 points on that. The first is, I make no bones about the fact that it might appear surprising that Multibank put forward the transcripts originally. The Court of Appeal in the BVI found it surprising as well. And there's a reference to their decision, paragraph 23, which is to be found in the Supplementary Bundle, tab 79, page 1362. But they show what they show. But my lords, context is everything. Because these transcripts, whilst they were not before Mr. Justice Lavender, were put before Mr. Justice Bryan, ex parte, by Multibank in 2021. And this is a very serious point that goes against them today when one appreciates the context. The judgment of Mr. Justice Bryan is at page 352 and following of the Supplementary Bundle, tab 45. And I'd ask my lords just to turn that up, please. I'm just checking the reference. I think I may have the reference wrong. I'll just check one.
It's tab 45.
Yes, I had given it correctly, my lords. I'm grateful. Yes, 352. So when Multibank went before Mr. Justice Bryan, ex parte, that was in the context of an anti-suit injunction in relation to the Luxembourg summons. And Mr. Justice Bryan was being invited to consider whether or not Mr. Smith was acting under duress. So the golden prison claim, I think it's been referred to. That is not the claim that VDHI bring in the BVI, which is that Mr. Smith colluded with Mr. Tyne. And my lords, if I could ask your lordships to go to paragraph 54 of Mr. Justice Bryan's decision, which is on page 361 and following. So in this part of the judgment, Mr. Justice Bryan says as follows: the allegations, under the heading, the allegations in the Luxembourg summon and the unauthorized disclosure. In the case of the claimant, it is the case of the claimant that the Luxembourg summonses contains allegations that are both extraordinary and demonstrably false. There's an allegation that Mr. Smith had no authority to bind the first defendant. The Luxembourg summons alleges that Mr. Smith was never a manager of the first defendant, never had authority to bind the first defendant, and therefore never had authority to enter into the settlement agreement, to approve the BVI consent order, or to instruct FinLaw to sign the BVI consent order. 55, the claimant submits on the basis of the evidence put before me that this is demonstrably incorrect. In particular, it is said that the transcripts of the meetings on the 9th and 10th of December 2020 as referred to in the BVI affidavit in pages 109 to 125 of Exhibit AD5, and the note of Mr. Duffy's video conference with Mr. Volotovsky and Mr. Smith show that Mr. Smith and Mr. Volotovsky represent that Mr. Volotovsky was aware of and agreed with the terms of the settlement. And if I could ask my lords just to go to paragraph 69 now on page...
Sorry to interrupt you, because of anonymity, who is the first defendant?
I will just check.
Mex Securities, my lord.
Yeah.
That was the company that instituted the Luxembourg proceedings.
I'm very
Mex
grateful.
Securities.
Thank you.
Thank you very much. Right, so it's whether he had authority to bind Mex Securities.
Yes, and it's the gold, and we'll come to I think the golden prison argument as well. So that's at paragraph 69, page 364.
Thank you.
Mr. Justice Bryan says, in the material before me, reference is made to particular examples which demonstrate that those allegations have no substance. Those include the transcripts of Dubai meetings, which it is said show Mr. Smith was not acting under any duress, and indeed it was Mr. Smith who first proposed the terms of settlement. Secondly, that Mr. Smith was not in any way prevented from contacting Mr. Volotovsky, and indeed was in regular contact with him throughout his trip, as evidenced by emails between them and also from Mr. Smith's numerous references in the meetings, as referred to in the transcripts, to his keeping Volotovsky up to date. So, my lords, what Mr. Justice Bryan concluded ex parte on the basis of the transcripts was that Mr. Smith appeared to have the authority to enter into the consent order, and he was not acting under duress. He was not invited to consider whether the transcripts showed improper collusion, which is obviously VDHI's case in the BVI, and he didn't do so. The transcripts suited multibank for that ex parte application, but not for this one. So, my lords, to reiterate, multibank accuse us of having conspired to bring dishonest claims in the BVI, but they do not set out the key allegations made in the BVI. They do not set out the evidence on which the BVI claims were founded, nor alert the court to the central evidence relied upon, i.e. the transcripts. And my lords, I may have detected some judicial surprise from the bench when I mentioned on day one that the key discussions in the BVI were transcribed. In my submission, Mr. Justice Lavender would have been even more surprised. My lords, just looking at this failure, it is difficult to conceive of a more significant one, and one that should not have occurred. My lords, this went to the heart of MGWL's case. There were no urgent timescales in preparing the application. The matter had obviously been under consideration for many, many months, if not years. I'll come back to this point. And my lord, just this breach of duty was, in my respectful submission, clearly sufficiently serious and culpable to warrant discharging the worldwide freezing order and not granting fresh relief. If an applicant can make an ex parte application this way and be allowed to keep their order, in my respectful submission, the court might as well dispense with the duty of full and frank disclosure altogether. And my lords, the judge did not go as far as to positively find that the failures were deliberate, and one can see that in paragraphs 8 and 120 of the judgment. What can be said, however, is that the failure was very serious and should not have occurred had the duty been properly understood and complied with by MGWL. There was therefore a high degree of culpability. Of course, a high degree of culpability does not require dishonesty. That is self-evident, but if authority were needed, one can find it in the Fundo Soberano decision of Mr. Justice Popplewell. I won't take the lordships to it, but it's in volume 3 of the authorities bundle, tab 41, page 946, and it's paragraphs 84 to 85. My lords, just staying with the judgments in the BVI, their relevance went well beyond the central element of the claim. In the affidavit of Yahya Tahir, in his first affidavit, the ex parte affidavit, paragraphs 25 to 43, so supplementary bundle, tab 93, page 1836, it was said that Mr. von Botica was involved in an insider trading scheme. Mr. Bloom was involved in an insider trading scheme. CSSF had made serious criticisms of VDHI, and this had led KPMG to resign as auditor of VDHI's funds. And the allegations were relied upon in paragraph 25 of MGWL's ex parte skeleton argument. Again, for your lordships note, the reference is supplementary bundle tab 91, page 1787. In fact, As explored in the hearing before Mr. Tinkler, all of these allegations had already been considered in the BVI, and Mr. Justice Jack had dealt with all of them in paragraphs 25 to 32 of his judgment dated the 28th of March 2022, supplementary bundle tab 59, page 763. The context of this judgment, it's another judgment to the discharge judgment, is that VDHI obtained the court's authorization to act as a claimant on behalf of all of the note holders in the BVI action in respect of the consent order. MBFX attempted to overturn that order and have VDHI ousted. They relied on all of these same allegations in an attempt to persuade the court to discharge the order. And Mr. Justice Jack concluded, A, it is unclear that Mr. Blome was ever convicted of anything, and whatever he did was purely a historic matter. B, the allegations against Mr. von Botica were very old, and the issues had never been tried. Mr. von Botica has no day-to-day involvement in the management of VDHI, and the CSSF has no concerns with his involvement. There was no evidence as to why KPMG resigned, but the fact that they were prepared to fund VDHI's claim in the BVI against MBFX suggested that their resignation was not due to any gross impropriety on VDHI's behalf. And whilst CSSF fined VDHI for regulatory breaches, the fines were low, and CSSF regarded VDHI as fit to be a regulated entity. And those findings were either not challenged or upheld on appeal. And the Court of Appeal's judgment is, for your Lordship's reference, it's paragraphs 107 to 118, supplementary bundle, tab 80, page 1466.
Say that against tab 80.
Tab 8080, my Lord, page 1466.
So that's
the-
so the original judgment is tab 59, page 763, and the Court of Appeal judgment is 80, tab 80, page 1466. And you gave me the paragraphs which were
In the Court of Appeal, 107 to 118. And in Mr. Justice Jack's judgment, 25 to 32.
yeah.
My Lord, all of this was highly material. VDHAG and VDHI were presented as being deeply implicated in repeated allegations of serious wrongdoing which had been uncovered by MGWL, and they were now presenting to Mr. Justice Lavender. All of this would have buttressed MGWL's submissions on good arguable case and risk of dissipation, as is recognised by the judge when he deals with the very same arguments in the context of risk of dissipation at paragraphs 48 to 49. MGWL should never have put forward this material without making it clear that there were good arguments endorsed in the BVI a year and a half earlier that these points didn't amount to a hill of beans. My Lords, MGWL also misled Mr. Justice Lavender by repeatedly stating that VDHI was the only party to the proceedings, the Scottish proceedings, which was also a party to the proceedings in the BVI. And I think my Lords have the references, but they are paragraph 16 of Mr. Urquhart's statement, so supplementary bundle tab 92, page 1819, and paragraphs 87 and 89 of Yahya Tahir's affidavit, supplementary bundle tab 93, page 1867. These statements were false, and they were known by MGWL to be false. In fact, on the 14th of April 2023, Clyde & Co., the firm of which Mr. Urquhart is a partner, wrote to my clients, the HK defendants, and the letter is supplementary bundle tab 82, page 1575, stating it's been drawn to our attention that both your client company and its officer, Michael Gollitz, have recently filed acknowledgements of service in the BVI, signalling an intention to challenge the BVI court's jurisdiction. My Lords, MGWL accepts that Lavender J, Mr. Justice Lavender, was misled, but claims that he was only misled in a minor respect. And that is not right. MGWL was asking the court to make a freezing order against my clients on the basis that it was expedient and just and convenient to do so. There was a real risk of dissipation. My clients have been the subject of an €85.2 million BVI claim for 18 months, and that undermined the application in three respects. First, had Mr. Justice Lavender been told that the HK defendants were parties to the proceedings in the BVI, he would, or which amounts to the same thing, might, have asked the obvious question, why are you not seeking a worldwide freezing order in the BVI? No satisfactory answer has been given to that question.
That's not a point the judge makes. The judge, when dealing with parties on this point, the judge limits himself to what he says at 114.
Well, my lord, at 114, the learned judge says, I'll briefly address the affidavit of Mr.
I
Young.
can see what it says.
I'm sorry,
I'm putting it to you.
Yes.
That there's nothing there about materiality. You're saying, well, they could have sought a worldwide freezing order against the same people in the BVI. That's your point as to materiality. So I'm just saying, well, it's not a point the judge made.
It isn't, my lord. I accept that. But the point I would make about materiality is my lords were taken to a part of the judgment, I'll find the reference in a second, where the judge considers at least one point, which I think is about the ability of the Scottish courts to grant freezing injunctions, freezing relief, considers the point and says, but in any event, that's not a material point. So I think it's clear that the points that the judge is emphasising here, the judge considers to be material. I accept, my lord, that the judge...
I see what you mean. So because he identifies one error but then says that's immaterial, you invite us to read that as saying if there's another error, which he doesn't say that about, then it is material.
Yes.
And what's the materiality that there could have been a worldwide freezing order granted in the BVI?
I think it feeds into the second and third points, if I may develop them. So the point is that they were the subject of a very significant claim there, and if Mr. Justice Lavender had been told that Multibank had commenced an £85.2 million claim against the HK defendants 18 months ago without any attempt to obtain freezing relief, in my submission it would have weighed in the exercise of his discretion. Equally, the fact that the BVI can grant worldwide freezing relief is also a material point, because if Mr. Justice Lavender had been told that Multibank was subjecting my clients to proceedings in 3 jurisdictions, the BVI being a claim made for MBFX for breach of alleged joint ventures, Scotland and here, he may have justifiably regarded the decision to do so as being manifestly oppressive. And my lords, even Tugashev, at paragraph 7, Roman numeral 5, states in terms the duty of full and frank disclosure extends to matters of intention and, for example, to disclosure of related proceedings in another jurisdiction. And my lords, MGWL may be content to keep instructing a sort of carousel of leading silks in multiple jurisdictions, but in the real world, in my submission, subjecting defendants to litigation in 3 jurisdictions does clearly give rise to a real risk of oppression. My lords, can I turn to the issue of delay? My lords, delay, or the lack thereof, was expressly raised as an issue with Mr. Justice Lavender. And in the ex parte skeleton argument, Mr. Justice Lavender was told that MGWL had only recently become aware and obtained evidence in relation to the unlawful means conspiracy. I think the relevant paragraphs in the ex parte skeleton argument are paragraphs 10 and 88, to be found in the supplementary bundle, tab 91, pages 1781 and 1812.
10 and 88.
10 and 88. And 88 is interesting. That's at page 1812. So third, as averted to in 10, the respondents may wish to submit that an injunction should not be granted because MGWL could have sought relief sooner. As to this, if MGWL is right in its allegation of the conspiracy, any criticism that MGWL should have been prompter in discovering the existence of the conspiracy would, it submitted, be of little weight in the overall balance. The explanation for when and how MGWL came to reassess the events of December 2020 so as to conclude that it was a victim of conspiracy is contained in Yaya's English affidavit at sections I, K, P and R. And my lords, it's one thing to say that delay is quite immaterial. It's quite another for MGWL to actively raise the issue ex parte and then for MGW to misstate the position. Mr. Justice Lavender was also told that the timing of the allegations of the conspiracy was driven by when the K2 report was obtained, and I think my lords have gone to that part of the transcript yesterday. And I'll just refer my lords to the page reference. It's in the transcript, pages 43 to 45. The bundle reference is supplementary bundle, tab 95, page 1899. In fact, I just asked my lords to go to it just for the sake of clarity. So it's supplementary bundle, page 1899. And one sees, and as I say, my lords, I apologise, I think your lordships were taken to this yesterday. But one sees at the top of page 43, Mr. Fennells, we deal at 87 with reputations and at 88 with timing. And my lord, we would say, well, we set out why we say we've done what we can as quickly as we can. Mr. Justice Lavender, yes, obviously the K2 report was fairly important in getting us to today. Yes, could you help me with where I find that? Yes, I'm just asking Mr. Rob, who's the junior, to look for that. 1221, Mr. Justice Lavender, is that in the Mex or in the other one in Mex? Thank you, right. And Mr. Fennells, and my lord will certainly see that with all the materials setting out the history of regulatory transgressions by the various defendants, yes, all of which were discovered long after the event by the claimant. Right, I see from, sorry, I'm pausing because Mr. Robb says sensibly as a matter of caution, no flourishes like that, Mr. Fennells. So if my lord could wind back for 15 or 30 seconds, very good, yes. Mr. Fennells, and just Mr. Justice Lavender, yes, I'll ignore that. In the introduction, K2 were retained in August. The report is dated this week. No doubt there were drafts. Mr. Fennells, yes. Mr. Justice Lavender, very good. Mr. Fennells, concluding, my lord, if my lord wishes to look more into the detail of timing, we've referred there to the section of Mr. Tahir's English affidavit at sections I, K, P, and R. We think that this may be an auto-update. We wouldn't want my lord to take the dates on the K2 report as being two. It could well be it's an automated update because they may have been engaged earlier. My lords, in fact, and actually, just once we're on the transcript, I'm sorry, before I carry on with this particular point, could I just refer your lordships to one point that Mr. Justice Lavender made right at the start, at page 1899, which, as one might expect, was to say, and this is on page 44, sorry, 1889, I apologise.
88.
Yes, 1889, I'm sorry, my lords. Towards the start, where Mr. Justice Lavender indicates what he has read. So this is on page 4 of the transcript, towards the bottom of the page, Mr. Justice Lavender. Yes, indeed, I'll let you know that I've read the skeleton of the two affidavits. Thank you, obviously, relatively quickly. So just returning to this point about delay, there was clear documentary evidence, my lords, which Mr. Justice Lavender was not taken to, that Mr. Tahir intended to bring his conspiracy claim as early as May 2022, when Mr. Duthie emailed Mr. Tahir to warn him of pursuing his, quote, mad conspiracy theory. And that email is at page 980, the supplementary bundle, and I'm going to come back to that shortly because that email is important in a number of respects. The K2 report had been substantially produced as early as July 2022. And the reference to that report is Supplementary Bundle, tab 69, page 1023. And my lords, to explain, and I'm not going to take my lords to each of these, but just so that my lords have a picture of the number of reports and when they were produced and what they show. The first was produced on the 5th of March 2022, and that can be found in the bundle, supplementary bundle. These are all references to the supplementary bundle, tab 56, page 655. And that is a report on VDHI and VDHAG. And it's from this that MGWL learned of the issues relating to Stephen Blohm and the class action lawsuit against Mr. von Bottger. And one can see that at page 656. There's a second report of the 22nd of April 2022, which can be found at tab 61, page 791. And that explored the connections between Colm Smith, CSM, and VDHAG. And from this, they learned that VDHAG was acting as portfolio manager for CSM bonds. One sees that at page 798. And my lords, if I may actually just ask your lordships to turn to page 794 of the supplementary bundle. One can see, my lords, in the introduction of this report that what K2 say is they set out previous reports. And one will see this in a few other reports. So one sees on page 794, K2 has already produced a report for the client dated the 5th of March 2022. So that's the second report. And then a further report is produced on the 8th of July 2022. And this is at tab 69, page 1023. I may just ask my lords just to go to that, if possible. So, tab 69, page 1023. And this is a report on VDHAG and key individuals. And one can see, for example, at page 1027, again, K2 refer to previous reports. And there's a report dated the 26th of April there. I'm not sure we've seen that, but certainly we've got the 5th of March and the 22nd of April. And from this, MGWL learned that VDHI had invested in engineer bonds. And one sees that in this report at paragraph 2.28, page 1036. My lords, another report was produced on VDHI on the 29th of July 2022. This is at page 1173. And again, one can see the previous reports referred to at page 1176. And again, I think, yeah, there's the 26th of April report that I don't think we have. And another one was produced regarding the ownership of VDHI on the 5th of August. That's at page 1216. And again, the previous reports are referenced at 1219. And when it comes to the Project Saxony report, which is the report that was relied upon before Mr. Justice Lavender, that's dated the 16th of October 2023. And it's to be found in the supplementary bundle, tab 86, page 1639. And my lords may...
The one that you've just given us the reference for, tab 86, page 1369,
yes,
is dated October...
The 16th of October 2023.
Yeah, and that's the one that Mr. Justice Lavender had.
My lords, it is, yes.
With that date on it.
Yes. And that's to be found at page 1639.
Yeah. Do you want us to go to that?
Yes, please, my lord. And my lords, this is, as I've just said, the report was relied upon by Mr. Justice Lavender, and my lords will note that it's similar in layout and content to the report produced in July 2022 at page 1023. It has slightly more information, but both reports tread essentially the same ground. And in fact, my lords, we've checked all the places in which MGWL's ex parte skeleton referred to the October 2023 K2 report. And it's clear that references to the July 2022 report would usually have worked just as well. So I will just give my lords references and not take you to them for present purposes. But paragraph 21 of the ex parte skeleton, page reference 1786, relies on the K2 report to say that the relationship between Ford, Cormack and Smith goes back many years. And this can be found in the July 2022 report at paragraph 7.6, page 1057, that's as between Ford and Smith, and at paragraph 8.9, page 1060, as between Cormack and Ford. There are 8 points.
What was the paragraph reference in the October 23 report?
The October 23 report,
Referred to in the skeleton.
I don't have that, my lord. I will give you that. It's referred to in paragraph 25 of the skeleton. I'll try and find that as soon as possible.
Okay, so the paragraph was to the skeleton.
The paragraph is to the skeleton at page 1786. I should say there are 8 points. That's the first. The second is paragraph 25.2 subpara 1. I'm afraid, my lord, these are references to the skeleton argument in the first instance. Paragraph 25.2 subpara 1 of the ex parte skeleton argument, page 1788 of the bundle, relies on the K2 report for the allegations that Mr. Blome was involved in the Ponzi scheme. And this can be found in the July 2022 report at paragraph 14.1 and following, page 1082. The third point, paragraph 25.2.4 of the ex parte skeleton argument, again page 1788, relies on the K2 report for the insider trading allegations against Mr. von Bottker. This can be found in the July 2022 report at paragraph 12.5, page 1071. The fourth point is paragraph 26 of the ex parte skeleton, relies on the K2 report for the fact that Mex Securities is in the process of liquidation. That's page 1788 again. In fairness, this was not in the July 2022 report, but it's of limited relevance to the allegations made. Paragraph 27, this is the fifth point, of the ex parte skeleton, same page 1788, relied on the K2 report for the fact that CSM was incorporated on the 6th of July 2020 with Mr. Smith as its sole director and shareholder. This is in the July report at paragraphs 6.1 to 6.3, page 1050. Sixth, paragraph 27 of the ex parte skeleton, again page 1788, also relies on the K2 report for the fact that CSM made substantial bond issues of which VDHCJ was portfolio manager. This is in the July 2020 report at paragraphs 6.18 and following, page 1054. Seventh, paragraph 38.2 of the ex parte skeleton, again page 1788, relied on the K2 report for the proposition that Ford, Smith, Duthie, Cormack and Gollitz were in a business relationship involving securities investments. This was primarily on the basis of the fact that VDHI had invested in Engineera, which they had linked to Cormack and Ford, and had invested in CSM bonds, which was linked to Smith. And one sees that at paragraphs 2.26 and following on page 1035, and 6.18 and following on page 1054. My lords, it's true that only the October 23 report had the additional information that Ford associated entities had purchased CSM bonds, but that was not a fact on which MGW placed any reliance. And eighthly, paragraphs 41 to 57 of the ex parte skeleton relied on the K2 report to set out asset information for the respondents. Now, some of that information is in the July 2022 report. In any event, it was never suggested that obtaining asset information relating to the respondents was what dictated the timing. My Lords, as I say, the Project Saxony report, so I'm just moving on to my next point, is the only K2 report which the judge was referred to. And what is notable is that if one looks at the introduction on page 1643, there is no reference to previous reports. My Lord, the way in which this was the way in which MGWL presented this to Mr. Justice Lavender was completely misleading, gave a completely misleading impression. And in my submission, there can be no doubt that the court was misled in relation to the timing and purported urgency of the application. And this was material for the reasons that we set out in our skeleton argument. And we cite G on commercial injunctions and Taylor and Kodabach. I'm not sure if I pronounced that correctly. But both of those are to be found in the authorities bundle. I'm not going to take your lordships to that now, but it's that one is G is in volume 5, tab 65, page 2021, and Taylor is in volume 4, tab 51, page 1271. And my lords, MGWL positively covered up the delay and has never explained it. Indeed, Mr. Taha maintains sworn evidence that he only became aware of the alleged conspiracy in September, October 2023. We can see that in Mr. Nasser Tahir's affidavit at paragraph 57, bundle reference, supplementary bundle tab 116, page 2183. Despite clear documentary evidence in the form of Mr. Duffy's May email that is untrue. So this leads to the Duffy email. My lords, I mentioned in the context of the Lavender Marshall application that on the 27th of May 2022, and I'm going to ask my lords to turn to this, so for your reference, the emails to be found in tab 65, page 980. On the 27th of May 2022, about a year and a half before the ex parte application, the recently fired General Counsel of Multibank, Adam Duffy, sent an email to Mr. Taher, the contents of which are directly relevant to the issues in dispute in Scotland. And I would invite my lords to read the whole email. And in the context of the Lavender Marshall application, I already referred, my lords, to the last page of the email under the heading Muddying the Waters, which is to be found at page 985. One sees there, and I'll read it again, my lords, if I may, because some parts are important for a different purpose. So under the heading Muddying the Waters, page 985, Mr. Duffy says, and I should start by saying that this email is dated the 27th of May 2022. One sees that on page 980. This email goes on to say, I know from our last meeting in London, so the meeting before May 2022, that you were trying to beat up a mad conspiracy theory against Michael Gollitz, Corn Smith and Stuart Ford. The theory is that Michael, Colin and Stuart, and probably me too, conspired to take your money from the Alpha Multibank notes and invest it in other products in which they were interested. There's not a scrap of evidence for this nonsense. I know for a fact that Stuart had nothing to do with Colin reneging on the consent order. He did this at the instigation of Slava and the Luxembourg lawyer, but I suppose that will not stop you from commencing a claim. The only reason for doing so would be a distraction. It would be an attempt to muddy the waters in the BVI dispute and put more distance between you and what happened in Dubai in December 2020. Now, my lords, this is a highly material email. It states in terms that the conspiracy alleged didn't happen and that there's an alternative explanation for Mr. Smith's change in stance. And whatever view one takes of Mr. Duffy's credibility, this, in my submission, is cogent evidence which should have been drawn to the court's attention. And MGWL did not take Mr. Justice Lavender to this email, nor properly draw it to his attention. Its relevance, though, must have been recognised because it's exhibited to the affidavit of Yahya Tahir, and it's mentioned in Mr. Tahir's statement, but it's simply referred to at paragraph 77, page 1862, tab 93, as a, quote, disparaging email, ... that was full of unsubstantiated lies. My lords, no explanations given in that affidavit of what those allegations are, despite their obvious relevance to the subject matter of MGWL's alleged claim. And this clearly, in my submission, doesn't come close to satisfying MGWL's duties. This is an email that goes to the merits and obviously the issue of a good arguable case, but it also goes to the issue of delay. And
Is the mad conspiracy theory, which is referred to, the same conspiracy as the one alleged in Scotland?
my lord, yes, broadly speaking.
Is it?
It's quite, you have to speak quite broadly for it to be, don't you?
Well, part of
This is more to do with the original allegation about withdrawing money from the so-called joint venture, isn't it?
well, it also refers expressly to Cole reneging on the consent order, and that really forms a central part of, as I understand it, the Scottish proceedings. So, my lord, my lords, it goes to the good arguable case and the issue of delay in my submission, and to call it full of unsubstantiated lies. I mean, it's quite something for a lie to predict with singular accuracy what will transpire 1.5 years in the future. My lords, it should be noted that and this is quite important because in the Scottish condescendence, it's alleged, and I'd like just to take my lords to this. So it's the Scottish pleadings in the supplementary bundle at page 222. Sorry, I'm not sure if I've got the. Don't think that's a correct reference. Can I just?
Which paragraph of the condescendence?
It's 34. Sorry, I'll just.
Page 1756, my lords.
So 1756, paragraph 34. This assertion in the pleading is directly contradicted by the Duffy email. It actually says the opposite of what the Duffy email says. So So 1756, paragraph 34. At a meeting in April 2022, now bearing in mind that the Duffy email is in May and he refers to our last meeting in London, attended by inter alios Mr. Tahir, Yahya Tahir, the Pursuers Operations Manager, Miss Christina Chakar, and Mr. Duffy. Mr. Duffy told the attendees that in his view, the reason why the 11th defender had sought to renege upon the settlement agreement and consent order had been made was because these steps had been directed by the first defender following the exertion of considerable pressure by him on the third defender. Mr. Duffy said that the first defender's motivation was to protect the 8th defender's ability to receive funds from the 9th and 10th defenders. So obviously the 9th defender is VDHAG, the 10th defender is VDHI, and the first defender and third defender,
Ford and Smith.
Ford and Smith, I'm grateful. So Mr. Duffy made observations about the first defender's checkered past, etc. So this paragraph in the pleading is directly contradicted by the Duffy email. The Duffy email says the opposite. The Duffy email says it's got nothing to do with, it's basically Slava and the Luxembourg lawyer. And my lord, in my submission, the fact that it contradicts this pleaded allegation makes it all the more shocking that the Duffy email wasn't properly referred to before Mr. Justice Lavender. My lords, I'm conscious of time, and as I said at the outset, we do set out our submissions on full and frank disclosure in some detail and respond to the assertions made by MGW World in our skeleton argument. I just wanted to make a few more points before we
We're leaving delay.
We are, my lord, yes.
Then I think yesterday it was suggested, well, the judge was wrong about this because the timing was dictated simply by the Scottish proceedings.
Yes, I think the answer to that, my lord, is that they could have brought the Scottish proceedings whenever they wanted to. And so the Scottish proceedings don't appear to have been triggered by anything. And one can see that these proceedings have been contemplated for a long period of time. So in my submission, it's not an answer to say that the injunction was sought within days of the Scottish proceedings. The question is why the Scottish proceedings were brought when they were brought.
Thank you.
My Lord, just a few more points before I move on to section 25. We do set out the numerous other failures of full and frank disclosure. I just wanted to flag one further full and frank disclosure failing, which your Lordships may not have in mind, which is a short point, but on the 24th of June 2022, MGWL actually entered into a deed of assignment, which is to be found in the supplementary bundle, tab 66, page 993. By its terms, MGWL purported to assign to MBFX all claims, whether present or future, against Mr. Gollitz and VDHAG. The consequence of that was that as at the date of the hearing before Mr. Justice Lavender, MGWL on Multibank's case had no claim at all against the HK defendants. Not a word of this was mentioned to Mr. Justice Lavender, but whether or not it was a genuine oversight, this was a grave breach of MGWL's duties of full and frank disclosure. It had commenced proceedings in Scotland without any right to do so whatsoever. My Lords, it's telling that this failure appears relatively low down on the list of the numerous failures of full and frank disclosure in this case. I just want to say a few words on conflation.
Was that point, the assignment point, that wasn't drawn to the judge's attention?
It was drawn to the judge's attention.
He doesn't deal with
but
it.
he doesn't appear to deal with it.
It's not in the judgment.
No.
So it was brought to his attention.
Yes, what I would say, my Lord, about the judgment is, and I'll try to find the references, there are certainly points that are specifically dealt with by the judge in the judgment, and clearly those are evident from the judgment itself. We've said in our respondents' notice that there are additional grounds, obviously, but there is at least one part of the judgment where he sort of where the judge generally refers to failures of full and frank disclosure. I'll find the reference, and it may be that some of the others can be fit into that, but only in a very general way. It's
I mean,
not.
if the assignment point is right, you're saying they had no cause of action.
Yes, that's absolutely right. I don't think that's disputed. I mean, I don't think that's actually disputed. I think the answer is, well, it's not material. We could have joined we could have joined a party. And I accept that. I mean, you know, these issues can be resolved, but it's just another example in my submission of the failure of full and frank disclosure. My Lord, just on conflation, it was sort of regularly said, well, you know, yes, we conflated, maybe mistaken my learned friend's submission, but broadly speaking, yes, there may have been conflation, but that's our case. You know, our case is that they all operate under the sort of VDH umbrella and everyone controls everyone. Well, that may be their case, but the point is on ex parte application, you've got to refer the judge to the other side of the case. And we deal with the points regarding alleged conflation in our skeleton argument for this appeal at paragraphs 83 to 85 and 96 to 97. We do say that when Multibank knows that VDHI, which is bringing the claim in the BVI, when VDHI fiercely rejects the suggestion that Mr. Gollitz is in practical control of it in the BVI, it was important for MGWL to make that clear to Mr. Justice Lavender. And this is an important point because the basis on which it is said that VDHI commenced litigation in the BVI is that Mr. Gollitz procured it to do so. But if, as VDHI was contending in the BVI, the decision to enter into the litigation was taken by someone else, against whom no wrongdoing is alleged, then that would mean that the BVI proceedings and the losses flowing therefrom, which are all or almost all of the losses, alleged losses, could not have been a product of the conspiracy. This is a point to which I'll return, time allowing, in respect of good argument case. My Lords, regarding, I think, my Lord the Chancellor's point yesterday on the 7 million euros, I would just say a few words, if I may. If I could ask my Lords to turn to the transcript of the ex parte hearing before Mr. Justice Lavender, so page 1895. And I apologise, my Lords, I appreciate that the court's been taken to these passages already, but So at page 1895 is the exchange between Mr. Fennells and Mr. Justice Lavender. And Mr. Fennells says, my lord, when the consent order was entered into, the terms were, broadly speaking, that Multibank Group would get back the large majority of the money and about 7 million would be left. Within that...
Which page you on?
Oh, I'm sorry, my lord, page 1895.
Internal page what, 28?
Oh, I'm sorry, yes, internal page 28, yes. So top of page 28, my lord. So, my lord, when the consent order was entered into, the terms were, broadly speaking, that Multibank Group would get back the large majority of the money and about 7 million euros would be left within that company in order to finance the claim which my clients were misled into thinking there would be made, and there was the potential for recovery of further losses. We do not know what's happened to that money, and it's in the promise of the investment into CSM. I'd emphasise it is the promise of the investment into CSM. As part of that, which is the inference for which we say the bribe was taking place, but we simply don't know what money was in fact paid over. So there's a reference to where the money's sort of come from, or possibly come from. And then there's a reference to a promise of investment into CSM. And then, as my Lord, the Chancellor referred to yesterday, the exchange continues on page 1896. What happens is that there's a short adjournment and Mr. Fennells comes back into court and he says, my lord, sorry to keep the court waiting for a moment, that's all right. We were trying to look for some references which would assist in relation to some of the questions raised before my lord before lunch. Sorry. Yeah. Can I deal with the first of those, please? You asked where the suggestion of bribery came from. Yes. And I took you to paragraph 129 as the beginning of that. And if I can take you to paragraph 130, please. And so that is a reference to the evidence which is in the supplementary bundle at page 1877.
Yep.
And so what this is an affidavit of Yaya Tahir. And at paragraph 130, it says, on the 22nd of April 2021, Michael Gollitz, Colin Smith, and Alexandros Theodoridis of VDH and Florian Weber, the notes calculation agents, exchanged emails and held a call about CSM. Moreover, in this email, VDH attached a portfolio summary showing that USD 3.6 million was invested in a 5-year bond as of Feb 2021 into CSM, with another 3.4 million in an 18-month bond. My lord, the short point I'd make is that this seems to address where the money is going into, but not where the money is coming from. So in my respectful submission, the passage at 130 doesn't actually contradict the erroneous impression that Mr. Justice Lavender may have been given about where the 7 million was coming from. So the 3.4 and 3.6 obviously add up to 7. But I think really 130 is directed at where that money may have gone to, as in the alleged bribe, rather than where it was coming from.
That's the one reference. The other 7 million is referred to at 1851, paragraph 45.13.
Where's the email that's referred to in paragraph 130?
I'm sorry, my lord.
Where is the email that's referred to in paragraph 130?
Paragraph 1, yes. I'll just try to find that, my lord. I'm told by Madam Junior, I'm not sure it's in the bundle. I'll endeavour to see if it is. Perhaps
Because you say it's not where it's not saying where it comes from, but that's precisely what Mr. Fennells says, top of page 31. That's where the figure of 7 million comes from, my lord, and that's money which, by inference, had no good reason to be going to CSM. So he seems to have thought that the email explained where the money was coming from. That's why I asked the question.
yes.
But as my lord says, there's another reference to a different 7 million earlier in the affidavit.
Yes, my lord, I'll endeavour to see if we can find the email.
Yeah.
I think I can only, my lord may disagree. My submission is that the latter point is about the inference of a bribe and where the money is going to, but I can only go so far with that point. I only have a few more points on full and frank disclosure, my lords. So I'm shortly going to move on to inexpedience. As I say, my lords, I apologise to repeat this. We have set out a full explanation of the numerous failings in our skeleton argument. I'd ask my lords to consider that. My lords, I do say that MGWL's criticism of the judge below was unfair. So many of the matters ventilated in the evidence, not just as regards the BVI consent order, but on the alleged links between my clients and the other entities, and historic regulatory issues. So many of those have been the subject of hotly contested litigation in the BVI and have been closely scrutinised by the High Court and the Court of Appeal there. And my lords, in my submission, the failure to even address the core material, the strong evidence of collusion that led to the judgment of Mr. Justice Jag, gives this court a clear window into the way in which this application was approached by MGWL. And it's no exaggeration, my lords, in my submission, once one gets into the details, to say that this is a case in which MGWL presented the background, the parties, the key aspects of the case and the application in a way which solely promoted its own interests. Two very short points, my lord, I'm afraid, sorry, three short points, and then I will move on to inexpediency. First, at paragraphs 108 to 109 of MGWL's skeleton argument, it is suggested that the judge failed to consider the potential impact on MGWL of discharging the worldwide freezing order. That is wrong. The judge was well aware of the function of the worldwide freezing order and the potential prejudice which MGWL might suffer as a result. And this is reflected by the fact that the judge was prepared to continue the injunction while MGWL applied for permission to appeal. And one sees that, I mean, my lords are aware of that, one sees that at paragraph 7 of the order, which is to be found in the core bundle, page 129. Secondly, at paragraphs 110 and 111 of MGWL's skeleton argument, it complains that the judge failed to consider or exercise a discretion to re-grant the worldwide freezing order. That is wrong. He did. Paragraph 120 of the judgment says, "It seems to me that the inevitable consequence is that this freezing order should not be renewed." He expressly uses the word renewed. He doesn't say that there is no discretion to continue or impose a fresh injunction. The judge is clearly exercising that discretion and reaching as a firm conclusion, and in my submission rightly so, based on the material, that it should not. Of course, the question of whether in the absence of full and frank disclosure an order should be set aside, and if so, whether it should be renewed either in the same or an altered form, is preeminently a matter of the court's discretion. And finally, my lords, just on the FCA watch list point, I should make 2 points. First is to make the point that our written submissions in the skeleton argument are supplemented by the points made by Ms. Salim of Howard Kennedy in her witness statement in the context of the Lavender Marshall application. That refers to the run of correspondence between MGWL and the FCA. And if I could just ask my lords to take a note of the reference, it's paragraphs 22 to 29, and it's in the Lavender Marshall bundle, tab 4, pages 29 to 31. And my lords, in my submission, whether MGWL knew about the watch list is immaterial. The judge below did not positively find that failures were deliberate. And as I understand it, anyone, frankly, could have Googled it and found it. And so, my lords, unless I can be of any further assistance, those are my submissions in relation to full and frank disclosure.
Thank you very much.
Turning to section 25, CJJA. And again, our position is set out quite fully in paragraphs 131 to 144 of our written submissions, which I'd invite my lords to consider. Before I address the court on what we say the law is and why we say that the judge below was right in the conclusions that he reached at paragraph 67, I just want to address two matters arising from my learned friend submissions right at the outset. These are, one, the evidence as to German law, and two, the effect of broad idea. There is, of course, a third point, which is Brexit, but I'll come to that in the course of my submissions. So as to German law, my learned friend said that there was evidence before Mr. Justice Lavender and Mr. Tinkler to the effect that the German courts, i.e. the courts with jurisdiction over Mr. Gollitz, VDHAG and their assets, do not grant freezing orders. That is wrong. The only evidence as to the position in Germany was a letter from Adelshaw Goddard, which is to be found in the supplementary bundle, tab 87, page 1725, in which they make clear, my lord, yes, tab 87, page 1725, in which they make clear that the worldwide freezing order is not capable of enforcement in Germany. However, they do not say that the German courts will not grant freezing relief. As I'll come to, this is a significant point. My lord, on to the effects of broad idea. My lord, we do not dispute that the consequence of the broad idea judgment recognised the jurisdiction to grant freezing injunctions in support of foreign proceedings separate and distinct from Section 25 CJJA. It doesn't follow, however, as my learned friend suggested, that all pre-existing fetters on Section 25 should now be thrown off. There are important reasons why that should not be so. In particular, the fact that a claim is made against the defendant under Section 25 is a gateway for service under Practice Direction 6B, paragraph 3.1, subparagraph 5. That is the only gateway under which we were served. Multibank could not obtain an injunction against us under the expanded broad idea of jurisdiction without Section 25, because Section 25 is the only means by which they can serve us. That gateway has no doubt been selected in my submission by the Civil Rules Committee with regard to the well-understood restrictions upon the application of Section 25, including, of course, concerning inexpedience, which is expressly referred to in subsection 2. Were this court to accede to Mr. Grant's suggestion that all previous guidance as to the restrictions on Section 25 should be recast and reconciled with the general jurisdiction to grant freezing orders, that would have a profound effect upon the court's ability to grant permission to serve out under this gateway. But also, there is no suggestion that it is an effect of any court or rulemaking, that is an effect that any court or rulemaking body has intended. They selected the amenability of a defendant to Section 25 as the litmus test for whether or not to subject a defendant to the court's jurisdiction for a reason. And in my submission, it would be wrong for this court to undercut the basis on which the gateway was crafted. So, my lords, those are my submissions on broad idea. A third important matter arising from my learned friend's submissions is the effect of Brexit upon Section 25. I will come to this. In my submission, sections 2 and 6 of the EU Withdrawal Act make clear that Brexit did not alter the effect which this court is to give to Section 25 CJJA. But I'll come on to this in the course of my submissions, if I may. So I'd like to start, my lords, just by turning to the main body of the judgment. So, core bundle tab 10, page 152. And one sees at paragraph 64, the learned judge says, I turn now to the test in section 25 CJJA 1982 as to whether it is not inexpedient to continue the WFO. There was significant legal argument about the degree of connection, if any, of the defendants to England that was required. This was in essence because a number of authorities in relation to Section 25 predate the UK departure from the EU. The defendants referred in particular to ICICI Bank and Dominico. The claimant referred in particular to Motorola, Credit and Uzan and emphasised the overarching just and equitable basis and the principles of comity. That passage of the judgment neatly encapsulated the parties' competing submissions on the point at the hearing below. I'd just like to give my lords a reference for that. So the first is our skeleton argument, paragraph 81 below, so that's supplementary bundle, tab 122, page 2699, and MGWL's oral submissions at pages 169 to 170 of the transcript, supplementary bundle, tab 125, page 2823. The judge goes on to state at paragraphs 66 to 67, as I've already decided there's no real risk of dissipation, I do not need to give a firm conclusion as to the appropriate test after the departure of the UK from the European Union. In any event, in my judgment, in this case, the test would result in the same outcome, whether it is as proposed by the claimant or is as proposed by the defendants. My brief reasons are set out below. 67. In my judgment, for the reasons set out at paragraphs 10 to 12 above, it could not be said that any of these defendants has any significant or, in my judgment, meaningful current connection to the UK or to England. If the defendants are right that this is the test, then none of these defendants pass. The injunction would be discharged and not continued on that basis. And the learned judge goes on to consider the claimant's theory. Now, returning to paragraph 67 of the judgment, MGWL accepts that the test as articulated in paragraph 67 is derived from the case law. But they argue that post-Brexit and post-Broad Idea it no longer forms part of English law, and separately they say it has no application because we're dealing with substantive proceedings in Scotland. I just refer, my lords, to MGWL's skeleton argument. Core Bundle tab 3, page 48. And paragraphs, it's paragraph 121.1. The judge applied a threshold test of significant, meaningful current connection to the UK or to England. Such a requirement derived from case law, cited to but not referred to by the judge, that predates, etc. And my lords, this is an important starting point because it frames the argument today. Because it's not asserted, for example, that the principles derived from the case law, such as ICICI, to which my clients referred the judge at first instance to, were wrong in themselves or proceeded on a misunderstanding of the earlier authorities. And my lord, just before I turn to ICICI, I'd like to start with Credit Suisse, which my lords were referred to yesterday. It'll only take a moment. It's in the authorities bundle 1, tab 17. Page 221. I'll be quite brief, my lords, with this authority. My learned friend, Mr. Grant, already referred my lords to passages from this authority. But as I'm sure my lords will know, in this case, the claimant brought proceedings in Switzerland, which is a party to the Lugano Convention, against the defendant who was domiciled in England, alleging that he'd conspired with one of the claimant's employees, a Mr. Voymin, to misappropriate some $21 million. And Mr. Voymin was a Swiss resident, but the defendant was domiciled in England. And Lord Justice Millett emphasised two considerations as highly material to be considered on the questions of expediency and proper assistance, namely the place where the person sought to be enjoined is resident or domiciled, and the likely reaction of the court seized of the substantive dispute. But I just want to take my lords to page 829, so that would be bundle reference 232. F to H, and I don't need to take my lords to the entire paragraph, but I would just ask my lords to note firstly that Mr. Kogi, who's the defendant, is resident and domiciled in England. That's between E and F at the start of the paragraph. But right at the bottom of that paragraph, Lord Justice Millett observes, it would be a very different matter if we were being asked to make a worldwide order against Mr. Voymin, but we are not. That's all I wanted to say by reference to Credit Suisse. And I should say, obviously Mr. Voymin lived in Switzerland. It's to be noted that this observation was made despite the fact that Mr. Voymin was alleged to have conspired with the defendant, resident in England, to misappropriate large sums of the claimant's money. So, my lords, I'd like now to go to ICICI, please, which is in bundle A2, tab 33. Decision of Mr. Justice Popplewell. And if I could start on page 626. Paragraph 1, just for context. This is the return date in an application which was for a worldwide freezing order, including an order for disclosure of assets worldwide pursuant to section 25 of the Civil Jurisdiction and Judgments Act 1982, in aid of a claim made in Belgian proceedings. The worldwide freezing order was made inter partes by Mr. Justice Eder on the 18th of July 2014 without any asset disclosure provisions. Paragraph 9, my lords, just over a few pages, page 629, one sees Mr. Justice Popplewell at the end of that paragraph observing, "I'm satisfied that the bank has, putting it at its lowest, a good arguable case that the defendant's indebted to it for the amount of debt." And then at paragraph 11, one sees the learned judge is satisfied of a risk of dissipation. Then we can pick up paragraph 12. I turn to the question whether it's expedient to make the order sought in the modified terms, which were advanced in oral argument. Section 25 of the Civil Jurisdiction and Judgments Act 1982 empowers the court to grant all forms of interim relief in aid of foreign courts unless, in the opinion of the court, the fact that the court has no jurisdiction apart from this section in relation to the subject matter of the proceedings in question makes it inexpedient for the court to grant it. The learned judge then considers Court of Appeal decisions of Rossiel and Oriental Commercial Shipping, that's at paragraphs 13 to 15. S&T Power Trading and Nordling, that's at paragraph 16. The Credit Suisse Authority at paragraphs 17 to 19. The Motorola Authority at paragraphs 20 to 24. And the Banque Nationale de Comercio Exterior Authority at paragraphs 25 to 26. Having done so, Mr. Justice Popplewell draws the strands together at paragraph 27. Drawing the strands together, I derive the following principles as applicable when the court is asked to grant a freezing order in support of foreign proceedings under section 25. 1, it will only be appropriate to exercise jurisdiction to grant a freezing order where a defendant has no assets here and owes no allegiance to the English court by the existence of in personam jurisdiction over him, whether by way of domicile or residence or for some other reason. Protective measures should normally be left to the courts where the assets are to be found or where the defendant resides is subject to in personam jurisdiction. And pausing there, my lords, this is a point made by Lord Justice Millett in the Credit Suisse case. In the authority, it's at page 827D. On to 27.2, where there's reason to believe that the defendant has assets within the jurisdiction, the English court will often be the appropriate court to grant protective measures by way of a domestic freezing order over such assets, and that is to say whether or not the defendant's resident within the jurisdiction, or for some other reason is someone over whom the English court would assume in personam jurisdiction. 3. Where the defendant's resident within the jurisdiction or is someone over whom the court has an in personam jurisdiction, for some other reason, a worldwide freezing order may be granted, applying the discretionary considerations which were explained in Kogi, Motorola, and Banco Nacional cases. 4. Where the defendant is neither resident within the jurisdiction nor someone over whom the court has or would assume in personam jurisdiction for some other reason, the court will only grant a freezing order extending to foreign assets in exceptional circumstances. It is likely to be necessary for the applicant to establish at least 3 things. A, that there is a real connecting link between the subject matter of the measure sought and the territorial jurisdiction of the English court in the sense referred to in Van Uden. B, that the case is one where it is appropriate within the limits of comity for the English court to act as an international policeman in relation to assets abroad. And that will not be appropriate unless it's practical for an order to be made, and unless the order can be enforced in practice if it is disobeyed. The court will not make an order, even within the limits of comity, if there is no effective sanction which it could apply if the order were disobeyed, as will often be the case if the defendant has no presence within the jurisdiction and is not subject to the in personam jurisdiction of the English court. C, it is just and expedient to grant worldwide relief, taking into account the discretionary factors identified at paragraph 15 of the Motorola case. I won't read all of those out, but I'd refer my lords to those set out there. So, now, my lords, it'll be noted that Mr. Justice Popplewell refers in ICICI to exceptional circumstances being required, not as a general requirement under section 25, but in circumstances where the defendant is neither resident within the jurisdiction nor someone over whom the court has or would assume in personam jurisdiction for some other reason. And to be clear, we've never suggested otherwise. MGWL attempts to distinguish this authority on three bases. First, it concerns the role of the English court within the Brussels-Lugano regime. Secondly, it is a pre-Brexit authority. And thirdly, this case concerns Section 25 CJJA proceedings in support of proceedings commenced in another part of the UK. MGWL has been unable to identify any authority to the effect that these are relevant points of distinction, and on the authorities which do exist, it is clear that they are not. Taking each in turn, so the first was the suggestion that ICICI is only authority for the role of the English court within the Brussels-Lugano regime. This did not appear to be developed by my learned friend Mr. Grant already. But my lords, we say it's clear on the face of ICICI that the principles which it sets out are not limited to Brussels-Lugano cases. My lords, as we've seen at paragraphs 13 to 27 of the authority, Mr. Justice Popplewell considered a number of cases in order to distill his statement of principles encapsulated in paragraph 132 of our skeleton argument. And one of those cases was Motorola and Uzan, the Court of Appeal. Motorola was not a Brussels-Lugano case, yet there was no suggestion that Mr. Justice Popplewell treated it as qualitatively different from the matter before him or other cases he considered. And to the contrary, in my submission, he rightly regarded it as entirely consistent with the principles he set out at paragraph 27. And furthermore, my lords, Mr. Justice Popplewell regarded the considerations which he had set out in ICICI as applicable to applications under section 25 in support of proceedings in Turkey. That is a separate authority. It's to be found in the authorities bundle. The cases Societe Generale and Goldas. It's in the authorities bundle, bundle A3, tab 38, page 811. I won't turn it up, but I'd invite my lords to consider paragraphs 81 and 82 of that decision. But my lords, the point is made clearest of all in Foul Oil, which was not a Brussels-Lugano regime case. And I just asked my lords, I think my lords were taken to it yesterday, but if I could just go to it very briefly. It's in A2, tab 31. Page 598. And my lord, just for context, Foul Oil was a case in which RBS applied for continuation of domestic worldwide freezing orders and for disclosure orders bought pursuant to section 25 of the Civil Jurisdiction and Judgments Act 1982, where the substantive proceedings were in Sharjah in the UAE. And one can see, my lords, at paragraph 37.5, so about halfway down the right-hand column on page 598, Mrs. Justice Gloucester says, as is implicit in paragraph 114 of the judgment of the Court of Appeal in Motorola and Uzan, even in a case such as the present, where the substantive proceedings are not taking place in a member state where jurisdiction is controlled by the provisions of the Brussels I Judgments Regulation EC number 442/2001, very careful consideration has to be given as to whether there is any real connecting link between the subject matter of the interim measures sought and the territorial jurisdiction of the court before which the measures are sought. This includes consideration as to the ability and power of the court acting in a policing role to enforce its orders if disobeyed. The learned judge there sets out the full passage from Motorola and Uzan. And my lords, the reason why there is a need for a real connecting link, even outside of the Brussels-Lugano regime, is in my submission obvious and emerges from Van Uden at paragraphs 37 to 40 and the Motorola decision at paragraph 114. If swinging injunctive relief is to be granted, it should be granted by a court that has a real connection with the subject matter of its injunction, and it should be capable of being enforced. Given the sound policy reasons for the need to show a real connecting link, whether one is dealing with EU cases or non-EU cases, one might wonder why Brexit would make a difference. And in my submission, it does not. If I could take my lords to section 6 of the EU Withdrawal Act, so Authorities Bundle 1, I should say, I'll be asking my lords to go to page 56. I should say at the outset that this is section 6 of the EU Withdrawal Act as it was enforced before Mr. Tinkler. And my lords, given that this is an appeal rather than a rehearing, my lords may not be surprised to hear that I do not submit that one should apply the law as it was that I do submit, sorry, that one should apply the law as it was enforced before the judge, albeit it doesn't make much difference. So one can see, starting on page 56, section 6, subsection 3, any question as to the validity, meaning, or effect of any retained EU law is to be decided so far as that law is unmodified on or after IP completion date, which I think is the 31st of December 2020, and so far as they are relevant to it in accordance with any retained case law and any retained general principles of EU law. And if one turns over a few pages, we're still in section 6, but on to page 58. Retained EU law, towards the bottom of that page, includes anything which continues to be or forms part of domestic law by virtue of section 2. Section 2 is the important part of that. I'll turn to that in a second. And retained case law, again on page 58, includes retained domestic case law and retained EU case law. And so one can see that those definitions refer to cases in the EU or domestic courts insofar as they relate to anything to which section 2 applies. And I should say section 6, subsection 6, the top of page 58, provides that subsection 3, which we started with, does not prevent the validity, meaning, or effect of any retained EU law which has been modified on or after IP completion date from being decided as provided for in that subsection, if doing so is consistent with the intention of the modification. And section 2 is to be found on page 51. And section 2 applies to EU-derived domestic legislation. I understand it to be common ground that section 25 CJJA is EU-derived domestic legislation. So, my lords, the purpose of all of this is to make clear that Brexit is not meant to suddenly detach domestic legislation from the decades of authority which has grown up around it. That authority is to remain, save to the extent that subsequent modifications indicate otherwise. My lords, I concede at once that Section 25 CJJA was modified on IP Implementation Day to remove references to the Brussels Regulation and Lugano Convention. And one sees the pre-Section 25 on page 42 and the the pre-implementation day on page 42 and post on page 46. But there is nothing in the modifications that gives any hint that the manner in which it is to be applied should be affected by Brexit. And so we say it should continue to be interpreted in accordance with the pre-existing law. Not least, my lords, because as I say, Section 25 functions as a jurisdictional gateway. And so it's important that it be reasonably certain. And disconnecting Section 25 CJJA from the authority which has grown up around it without clear legislative provision requiring the court to do so is a recipe for confusion, in my respectful submission. And in any event, my lords, one can see Section 6 as it's currently in force in the authorities bundle at page 68.
So Section 25, as it's now in force, is limited to other parts of the United Kingdom and Hague Convention states. Is that right?
My lord, on its face, yes, but not in fact, because a separate order was made that effectively applies it to the rest of the world, and that is referred to in REFCO, and I can give my lord the reference and
Yeah, okay.
the relevant provision.
Don't need it, but follow.
And so we can see Section 6 as it's currently in force at page 68. The only difference for present purposes is that the term retained EU law has been swapped, I think, for assimilated law. But one has the definitions, and they appear on the same page.
Sorry, which page was that?
So
That's currently in force?
as currently in force is page 68, and one sees, for example, my lord, on page 70, subsection 3 does not prevent the validity, meaning, or effect of any assimilated law. And one sees the definition of assimilated law. Be corrected if I'm wrong, but I don't think there's any material difference. Not that we've identified.
Thank you.
Yeah.
And so the suggestion, my lords, that the principles in ICICI do not apply because the court's considering an application. Sorry, I'm moving on to my next point. The suggestion that the principles in ICICI do not apply because the court is considering an application in support of Scottish proceedings. As to this, my lords, first of all, this is pure assertion. It finds no support in case law or statute. And my lords, Section 25 itself, on page 46, refers to other parts of the UK in exactly the same terms as other states. Secondly, nor does it make logical sense. The United Kingdom might be one entity, but it contains 3 different systems of courts, each of which adopt different policies. We've heard that the Scottish courts do not typically grant extraterritorial orders. The evidence of Mr. Brown is that the Scottish courts are much more relaxed about granting permission to serve out of the jurisdiction than the English court, and one sees that in paragraph 17 of Mr. Brown's evidence at page 1734. So why, I ask rhetorically, should the English court set aside the rules by reference to which it makes its own orders just because the court asking it to do so is Scottish rather than, for example, Irish?
Are there any cases, in fact, where that Section 25 has been applied in relation to proceedings in Scotland?
Well, we haven't found any, my lord. None have been cited by
Or Northern Ireland?
No, my lord, we haven't checked. We can, but none spring to mind.
Doing so, but it sounds as if the answer is no, generally. Otherwise, you would have picked it up.
Yes, none spring to my mind, and certainly none have been deduced by the appellant in support of this.
Well, I mean, your main point, I suppose, is that there's nothing in the statute to to suggest that the approach that the court should adopt in relation to another courts in another part of the United Kingdom should be any different from the approach it would adopt in any other Section 25.
My lord, absolutely.
And I just wanted to check there weren't any,
Yes.
was it any
I don't think so, my lord.
crossover cases that actually address the point.
Yes.
Thank you.
So, my lord, just moving on to the application of principles. When read in light of these principles, the judge's decision in relation to expediency cannot be faulted.
No.
He correctly identified at paragraph 67 that neither of the HK defendants have any meaningful current connection to the UK or to England. And at paragraphs 69 to 71, that this is not an exceptional case in which relief should be granted by the court acting as international policemen, despite that fact. In such circumstances, the judge was right to find that granting the relief sought in this case was inexpedient. My lords, the HK defendants reside and have all of their assets in Germany. See Mr. Gollitz's affidavit in the supplementary bundle, tab 101, page 1942. VDHAG has no assets or employees of any kind in the United Kingdom. It has 3 small clients there, amounting to, as an estimate, less than 1% of VDHAG's client base by value. That's in Mr. Gollitz's affidavit, supplementary bundle, tab 107, page 2036 at paragraph 21. On MGWL's own evidence, the German courts will not enforce the worldwide freezing order, and the reference for that is supplementary bundle, tab 87, page 1725. Thus, there is no practical means of enforcing the worldwide freezing order. My lords, these proceedings were also oppressive. They were the third in a series of claims brought against Mr. Gollitz, a fact hidden from the judge ex parte, which piled pressure on Mr. Gollitz, forcing him to instruct yet another team of lawyers and deal with yet another set of procedural obligations. And my lords, as to each of these 6 submissions made by MGWL at paragraphs 130, this is in their skeleton argument, paragraphs 137 to 147, which is in the core bundle, tab 3, starting at page 53. Just ask my lords to turn that up, please. So at paragraph 137, it is said that there is no inexpediency because the English court is readily able to understand the Scottish proceedings. Well, my lord, that is wrong on its own terms.
So paragraph?
I'm sorry, my lord, paragraph 137, which is to be found at page 53
Yes.
of the core bundle. So it said that there's no inexpediency because the English court is readily able to understand the Scottish proceedings. But as I say, that is wrong. The Scottish procedure is wholly unfamiliar to the English court and has concepts which my lords are now well familiar with, such as diligence on dependence, which have no precise parallel in this jurisdiction and cannot be understood without evidence explaining them. My lords, in any event, it takes far too narrow a view on why Section 25 CJJA, on why the English CJJ application is inexpedient. As the authorities made clear, it is vital to consider the extent of the links between the HK defendants in this jurisdiction, and there are not any in this case. My lords, at paragraph 138, page 54, it said that the fact that Scotland lacks the jurisdiction to grant the relief sought is a factor in favour of granting the ancillary relief. My lords, as noted by Mr. Tinkler at paragraph 96 of his judgment, that submission is not supported by MGWL's own evidence, which is that the Scottish court is, quote, generally reluctant to make extraterritorial freezing or disclosure orders, not that it cannot do so. And that's in Mr. Brown's affidavit at paragraph 16, page 1734. And my Lord the Chancellor observed yesterday that there was a difference between a court that technically has the power to make extraterritorially orders, but that doesn't as a matter of practice, on the one hand, and a court that could and did make such orders, depending on the facts, but very rarely did so. I
That's
think
one of the factors mentioned by Mr. Justice Popplewell in his summary in ICI, whether it is the policy of
Yes.
the foreign court not to grant such orders.
Yes. And my Lord, the Lord Chancellor, I think drew that distinction.
Yeah.
And I suggest that the use of the words generally reluctant suggests that there are cases in which the Scottish court will make extraterritorial orders. And so we're in the second of those two buckets rather than the first. My Lords, at paragraphs 139 to 142 of MGWL's skeleton argument, it's asserted that it's expedient for Section 25 CJJA relief to be granted on the basis of such connections as exist between the HK defendants and England, on the basis that Mr. Gollitz lives close to England and Wales, and that he's travelled to England in the past, there being no evidence that he continues to do so. My Lord, these are inadequate connections. The relative positions of Germany and England on the planet's surface are irrelevant for these purposes, I would say. And whilst the fact that, and the fact that Mr. Gollitz has occasionally visited England in the past is not evidence that he might do so in the future. My Lord, MGWL's skeleton argument states that Mr. Gollitz accepts that he travels regularly to England for business purposes, and it refers to Mr. Gollitz's third statement dated the 7th of December 2023. But that statement, paragraph 27, which for your Lordship's reference is in the supplementary bundle, tab 119, page 2294, says, since October 2019, I've travelled to the United Kingdom on 6 occasions for trips varying in length between 2 and 4 days. So that is 6 times in over 4 years. That, in my submission, is not regular travel, and it is not said to be ongoing. Furthermore, my Lords, MGWL's submission of the courts in which the respondents or their assets are located do not grant analogous relief, which they say in paragraph 141 of their skeleton argument, is without evidential support, as I've said, by reference to the letter from the German lawyers, a point that I made at the start of my submission.
His position, the letter doesn't address that, and therefore there is no evidence either way. I mean, you're right.
I think that's right.
It doesn't address it. But
Yes, it doesn't address it.
Therefore, there is no evidence
Yes,
either way.
yes. My Lords, we also say, and this is a point that I've in a sense already made, that subjecting Mr. Gollitz to proceedings in 3 different jurisdictions was oppressive. For the reasons that I've explained, it poured pressure on Mr. Gollitz and forced him to incur greater legal costs and to devote more time and effort to court hearings than can be justified. The BVI proceedings may have been discontinued in the event, but one has to judge matters as they appeared before Mr. Tinkler. At paragraph 145, MGWL claims that the usual reluctance of courts not to interfere with other courts' proceedings do not apply in this case because England and Scotland are not independent states. I think I've dealt with that point. And finally, at paragraph 146, MGWL submit that if it's necessary for it to show that this is a case in which the court should act as international policemen, notwithstanding the fact that neither HK defendant has residence or assets here, it can meet that test. My Lords, for reasons that I'll shortly explain, the judge was right to observe that the court will only act as international policemen in respect of persons with no residence or assets in the jurisdiction in exceptional circumstances, such as those in Haiti and Duvalier and Fundo Soberano. And so just on the subject, my Lords, of the court acting as international policemen, could I ask my Lords to pick up what is said on this in the Motorola decision? So authorities bundle A1, tab 21. Could I start by referring your Lordships to what the Court of Appeal there said about the Duvalier case? And so that starts at paragraph 66 of the Motorola decision. which is on page 343. So I'll just read from 66. Second, it is clear that the principal basis of the decision was the fact that England was the only place which had any known connection with the asset concealment scheme, and was therefore the place where information was most likely to be obtainable. The court having earlier ordered the solicitors to provide information, an application to set aside which had failed. In this respect, at the beginning of his judgment, Lord Justice Staunton described the asset concealment scheme and the employment of English solicitors as the agents of the defendant in its implementation as the two striking features of the evidence. Further, having referred to the judgment of the European Court in Denilau, to the effect that it is the courts of the contracting state where the assets subject to the measures sought are located, which are best able to assess whether to grant or refuse the measures sought, in which point he saw considerable force, Lord Justice Staunton said, but the Republic, when it launched the English proceedings, did not know where the assets were located. One of its objectives was to find out. The proceedings were started here because it was here that the information was available. Finally, Lord Justice Staunton stated, it's beyond question that the injunction granted by Mr. Justice Knox and upheld by Mr. Justice Leggett was a most unusual measure, such as should very rarely be granted. This case is most unusual. It's not the nature or strength of the Republic's cause of action which puts it in that category. What, to my mind, is determinative is the plain and admitted intention of defendants to move their assets out of the reach of the courts of law, coupled with the resources they've obtained and the skill they've hitherto shown in doing that, and the vast amount of money involved. This case demands international cooperation between all nations, as the judge said. If ever there was a case for the exercise of the court's powers, this must be it. And I'd just like to carry on reading at 68 and 69. In an article written in Essays in International Litigation and the Conflict of Laws, referred to by Lord Justice Millett in Cowley's case, Lawrence Collins commented as follows: for an English court to enjoin a person properly subject to its jurisdiction from disposing of assets abroad cannot in this sense be regarded as exorbitant. Perhaps Republic of Haiti and Duvalier goes to the very edge of what is permissible. But the sole connection of England with that case was the presence in England of solicitors with access to foreign assets. The exercise of jurisdiction can be justified on the basis that the solicitors will be treated as agents of the defendants and the relevant information was located in England. The very same view of the ratio of Republic of Haiti and Duvalier is expressed in Dicey and Morris Conflict of Laws, where it stated that the relief was effective because the defendants had solicitors in England who held assets for them abroad, and therefore the fact that the court had no jurisdiction apart from Section 25 did not make it inexpedient for the court to grant the relief within the meaning of Section 25(2). Our case, my lords, is of course entirely different and nothing like this sort of case. And it really does have to be exceptional cases such as this. And this is actually made clear in Motorola, where my lords may recall when I took my lords to this decision in connection with the Ladden Marshall application, where the fraud alleged against the defendants, if correct, was fraud on a massive scale, but it was held not to stand relevant with Duvalier's case. And at first instance, I could just go to page 350, which is the decision of Mr. Justice Steele. So paragraph 90. First instance, the judge at least went as far as to accept the proposition that where defendants were not resident in the jurisdiction and or had no assets here, it would be a rare case in which it would not be inexpedient to grant leave, something which MGWL cannot bring itself to accept. So at paragraph 90, the judge stated that he accepted the proposition that where the defendants were not resident in the jurisdiction and or had no assets here, it would be a rare case in which it would not be inexpedient to grant leave. He acknowledged that in Cowie's case, the court was considering the position of a defendant to foreign proceedings who was resident and domiciled in England. The observations of Lord Justice Millett were made in that context, and that Lord Justice Millett had stated it would be a very different matter if the court were asked to make a worldwide order against the co-conspirator of Mr. Cohey. He also referred to the observation of Lord Justice Bingham in Cohey's case, that it may be thought to weigh in favour of granting such relief. The defendant is present in this country and so liable to effective enforcement of the law made in personam. Always provided by granting such relief, this court does not tread on the toes of the primary court or any other court involved in the case. At 91, nonetheless, the judge stated that despite the rarity of cases in which it would be expedient to grant worldwide relief against the defendants who were not resident in the jurisdiction and had no assets here, such cases could arise, citing Republic of Haiti and Duvalier, and relying on the passage from the judgment of Lord Justice Staunton, which we've quoted in paragraph 67 above, He held the decision in Duvalier's case demonstrated the fact that the relevant defendant was not resident and had no known assets here was not as such determinative, observing that it could be sufficient that within the jurisdiction there was a firm of English solicitors with knowledge of the whereabouts of the defendant's assets, in the context where the defendants were showing determination to keep their assets out of reach of the claimant. And could I ask my lord just to read the conclusion of the judge at first instance, which is at paragraph 92. My lords, as I've said, and for your lordship's reference, that the relevant passages that I took your lordships to a few days ago of Judge Rakoff in New York were paragraphs 10 to 12 of the Motorola decision. So the fraud alleged was on a massive scale. However, in Motorola, if one turns to paragraph 123, so here we're picking up on the judgment of the Court of Appeal. Paragraph 123, fifth, albeit the fraud alleged against the defendants was, if correct, fraud on a massive scale, we do not think it stands relevant in comparison with Duvalier's case for the reasons advanced by Mr. Strauss, see paragraph 111 above. Finally, we also agree that no question of comity arose for consideration in Duvalier's case, which rendered it inconsistent with the submissions made of the first three defendants. And if I could ask my lords to turn to paragraph 111. So these are the reasons advanced by Mr. Strauss. Fifth, the judge was wrong to hold that the facts of the case were even stronger than Republic of Haiti and Duvalier in crying out for some form of international cooperation. Mr. Strauss submitted the judge appears to have misunderstood the reasons which led Lord Justice Thornton to use the words he did in Republic of Haiti and Duvalier, based on the particular facts in which the claimants were a sovereign state seeking to recover assets looted by a dictator who'd held an iron grip on his country for a number of years and had operated a sophisticated scheme to conceal assets and move them about in advance of steps taken in legal proceedings, incidentally using the English solicitors as agents for that purpose. He also submitted the judge failed to give any weight to the fact that the decision in Duvalier's case rested also upon the fact that there were present within the jurisdiction the defendants' English solicitors who were known to possess information as to where the defendants' worldwide assets were located and thus were amenable to sanctions if the disclosure order made was disobeyed. And my lords, I say our case is nothing like the extreme case in which the court will act as international policemen to freeze assets belonging to someone who is not domiciled here and which are not located here. My lords, unless I can be of any further assistance, those are my submissions on section 25.
Yeah.
I propose now to hand over to my learned junior, Mr. Kinman, on risk of dissipation.
You're going to deal with risk of dissipation. I am, my lord.
My lords, the starting point is that the judge's conclusion that there was no risk of dissipation is an evaluative decision, which is what we well familiar to this court. An appellate court will accord a high degree of deference, and will only interfere with it if multibank can show some error of principle, a relevant matter left out of account, an irrelevant matter taken into account, or that the judge's decision was plainly wrong. And in my submission, the appellant cannot demonstrate any such flaw in the judge's judgment. Running through the criticisms made by my learned friend. The first was a criticism of the way that the judge expressed himself at paragraph 42 on page 145 of the court bundle. Where the judge said, this court has to assess whether there's a real risk of assets being dissipated unjustifiably. In other words, moved to places where they cannot be subject to the jurisdiction or enforcement of the courts to which they could be subject prior to the removal. Now, as I understood my learned friend's point, it was said this is wrong because there's other forms of dissipation beyond merely moving assets outside jurisdiction. In my submission, this is somewhat unfair on the judge because the appellant themselves, before the judge, occasionally used the word move as a synonym for dissipation. I can take the court to the transcript, but if I can just give you the references and read what was said. On day one, page 154, line 12, page 2819 of the bundle. Well, if we were wrong not to pull the trigger a year ago, or July 2022, or sometime near after, then the only people who are going to suffer for that is ourselves, because assets might or might not have been moved. And at day 1, page 158, lines 16 to 21, page 2820 of the bundle, the urgency then arises in the BVI and the Caymans and the Channel Islands because of the date you trigger the main claim here in England. And that is exactly what the position is here, that unless and until they actually think they are on the hook, then they may or may not move their assets or feel the need to move their assets. And in any event, my lords, I say there's nothing in the point because the judge clearly has in mind that he's concerned with questions of enforcement beyond the merely jurisdictional. One can tell this from the terms of paragraph 42, where he uses the words jurisdiction or enforcement. And it's also clear that the judge had in mind that dissipation might manifest in other ways, such as transactions at an undervalue, which he refers to as a form of dissipation in paragraph 52 on page 147. Well, I mean, sorry, 52 starts on 147, but it's actually on across 147 to 148. Next, and rather more substantively, my learned friend complained about references in the judge's reasoning to the fact that there was no evidence that my clients had dissipated their assets, and the fact that the allegations against my clients were not ones of moving money. And it's said by my learned friend that the judge treated these as prerequisites to obtaining a freezing order. But in my submission, that's not a fair reading of the judgment. The judge clearly regards these as important factors to weigh in the balance, but not that they are necessary to any application for WFO. And in my submission, that's entirely in accordance with the authorities. Just to make good the fact that he doesn't regard them as necessary prerequisites, one can see at paragraph 55 on page 149. Here he makes the point that the allegations against my clients are not allegations of moving money or money laundering. Now, if it were the case that the judge regarded that as necessary for the obtaining of the WFO, he would have said so. But he doesn't. He goes on to consider other factors. Indeed, the next one he says is one that he clearly regards as perhaps weighing against us. It is to do with the representation about changes in usage. So there's no suggestion there that he regards the fact that there's no allegations of moving money as game over for the application. It's just something that he weighs in the balance.
But he also refers to the points he's made about the 10th defendant,
Yes.
which is a reference back, presumably, to 52, where he talked about transfer at an undervalue as an example. And that's just another example of how you might unlawfully dissipate assets.
Yes, exactly.
So it seems that he's really, I mean, it's all, some of this is phrased in a pretty loose way, frankly. But I think what he's got in mind is the different ways in which assets might be dissipated. He's not trying to suggest that it has to be, for example, moving money or money.
Well, yeah, no, certainly he doesn't think that that's the only way that that's the only risk that one has to dissipate. But what I'm going to come on to suggest is that when he's talking about when he repeatedly references the fact that the allegations made against the respondents before him weren't allegations of moving money or dissipating assets. What he has in mind is the authorities that say one can infer a risk of dissipation from the fact that there's been a good arguable case established against the respondents. Well, one has to look carefully at the good arguable case that has been established and examine the allegations made and see whether they are really the sort that justify piggybacking, as it were, your findings on good arguable case into risk of dissipation. My submission, this is what the judge has in mind. He's saying, well, I accept I've found that these individuals, there's a good arguable case that they've engaged in an unlawful means conspiracy. But the nature of the allegations made in that case, in the judge's view, and it's the view that he was entitled to come to, weren't the sort of allegations that mean you then say I therefore find there's a risk of dissipation. It's not the sort of case where the good arguable case established is that there's been a fraud whereby someone's stolen someone's money and hidden it. That's my submission there.
Yeah.
The second consideration, which my learned friend submits that the judge regarded as necessary to found a freezing order, and again I say that wasn't how the judge was approaching it, is the fact that there was no evidence of dissipation of assets. So one sees at paragraph 59, page 150, the fourth and ninth defendants have been party to the BVI litigation for some time without any freezing order on them. There's no evidence of any dissipation of assets by them, let alone any unjustified dissipation. Now, again, the judge plainly regards this as an important factor, but he doesn't say, and therefore you can't get a freezing order. He just says, he just regards it as an important factor in the weighing exercise, as reflected in paragraph 61. He considers a number of things, having considered the various allegations made against my clients. And he doesn't say there's no evidence of any actual dissipation having been carried out, therefore you lose. He just says one of the things that I'm taking into account is that there's no evidence of actual dissipation. And as I say, in my submission, that was entirely in accordance with authority. Now, I'm going to take my laws to the Magomedov case. I'm conscious that and only briefly, the reason why I'm doing this is because it's the case that the judge specifically refers to of having
This is
read.
Mr. Justice Butcher, is it?
Yes, it is.
Yeah.
Yes,
Where's
Mr.
that?
Tinkler. Sorry.
Which tab?
Oh, 41 Authorities Bundle 5. Sorry, not 41, 58.
Yeah.
And page 1852. This was a passage that the judge said he had read in paragraph 41, sorry, of the judgment. And
Seems rather a shame that at tab 57 we have 200 pages to which nobody's referred to.
I can only apologise.
I don't know why we've got that case.
Well, my lord, we will be going to that case in the context of our arguments on good arguable case. Now, I can't promise we'll be
200 pages of it.
looking at all of the pages, but we'll see how we go.
Right, so, okay, we're looking at paragraph 58, are we?
We are. And particularly 2, 3, 4, 5, and 6.
Say those again, 2, 3.
Roman numerals 2, 3, 4, 5, and 6.
Should we just read those to ourselves?
Sorry, my lord, if you wouldn't mind. And in my submission, 2, 3, 4, and 5 are what the judge has in his head when he repeatedly refers to the nature of the allegations made, the nature of the good arguable case which has been established. And Roman numeral 6 is what he's got in his head when he says there's no evidence that there's been any dissipation of assets following the fact that the notification of the BVI proceedings to my clients in July 2022. And so I say that there's no error of principle here. Now, my learned friend complains that my clients never put in any evidence of what they had done between the notification of the BVI proceedings and then Mr. Gollett serving his affidavit setting out his and DHCJ's assets. And that's true. But my clients were never asked to do so. And it was never suggested at first instance that there should be a kind of adverse inference arising from the fact that we hadn't volunteered that information. And my learned friend says that if a freezing order can be discharged on this basis, the jurisdiction would withdraw on the vine. But in my submission, that's not right. Most applicants don't apply for freezing orders 16 or 18 or whatever it is months after commencing proceedings for 80 million euros against the respondent. And those that do, if they are well advised, will know that the fact of the delay may pose a problem for their application. Certainly if they can't show something which has suddenly changed their view of the risk of dissipation posed by the respondent. And in my submission, there's absolutely nothing surprising about that. My learned friend then turned to paragraph 60, where he said that the judge wrongly discounted the possibility of a concealed interest in CSM. Now, as to that, we say, as we said yesterday, that none of the Ladd & Marshall documents show that my clients have any kind of equity interest in CSM. And to the contrary, the documents, even those which are said by my learned friend to portray the true state of affairs, show Mr. Smith as a sole shareholder. As for potential interests in fees, DHCJ has always been open about the fact that it receives fees by reason of its relationship with CSM. And in his third witness statement, as my lords have seen, Mr. Gollett's made an unforced concession, I'm not sure confession is the appropriate word, but an unforced disclosure that there was existing a fee agreement between him and Regal referable to investments in CSM, but that fee agreement was never performed. And as Mr. Calfon said yesterday, Multibank have Regal's documents. So if it had been performed, it's a fair inference Multibank would have been able to tell him. Mr. Grant also took you to a draft loan agreement dating from May 2023. As to this, I say that the draft was circulated years after the events in dispute, and it does not show money moving from CSM to Mr. Gollett. Turning to paragraph 61.5 of the judgment at page 151. My learned friend criticised the judge's reliance upon the fact that the German regulator had not expressed any concern regarding Mr. Gollett. Now, it was said that that was a factor that shouldn't have been taken into account. In my submission, it clearly is. My clients are regulated by the German regulator, who have been informed about this dispute. That's the second witness statement of Mr. Gollett at paragraph 13, page 2035. And they continue to regard Mr. Gollett, seemingly, as a man who is fit and proper to have managed client money. So I say that's relevant. I don't say it's determinative by any stretch, and I don't say that the judge didn't think it was determinative.
Well, at the moment, I can't see why it wouldn't be relevant, frankly.
Well,
As you say, it may not have been determinative, but if you look at it the other way around, if the German regulator had concerns about your client, which had been recently expressed,
yes,
that the company was dodgy or something, that would be relied upon very strongly as an indication that there was a risk of dissipation.
quite much.
And so the obverse must really follow, mustn't it? It must be at least a relevant factor.
We say so, my lord. A further criticism made in paragraphs 86 to 87 of Multibank Skeleton, but not, I think, addressed orally, is that the judge considered matters said to give rise to a risk of dissipation separately, rather than considering them in the round. But in my submission, that's not a fair reflection of the judgment. One sees at paragraphs 54 to 60, the judge carefully set out the principal arguments relied upon, And then having done so, he has a sort of conclusion at paragraph 61, which I read as a, taking it all together, here are my conclusions paragraph. Now, if my lords are not with me, and the court does regard itself as bound to reach its own view on the risk of dissipation, I need to address my learned friend's 4 pillars. And I say they do not give rise to a risk of dissipation, or establish a risk of dissipation. The first pillar, my learned friend, was the UCITS issue. My learned friend took you to various documents from the 3rd of December 2020, in which Mr. Gollitz referred to there having been a recent change in the UCITS regulations. And it's accepted there was no recent change. But what my learned friend did not take you to was an email sent by Mr. Gollitz to Mr. Duffy, who of course is Multibank's chief counsel, the next day, at page 181.
Of what?
Sorry, the supplemental bundle, my lord, 181 tab 20. I'm reminded that it may be marked because Mr. Calfon mentioned it in the chronology.
Yeah.
This is an email in which Mr. Gollitz identifies the provision which is causing an issue. And in my submission, it would have been obvious to Mr. Duffy, almost at once, that there was no recent regulatory change. Not least because the document says on the top of it, Directive 2009. And it would have been obvious to Mr. Gollitz that it was obvious to Mr. Duffy that there was no recent change. So, in my submission, all this amounts to is that Mr. Gollitz said something on the 3rd of December, it was wrong, and then he communicated the correct position on the 4th. And we say that that's powerful evidence that Mr. Gollitz's statement that there had been a regulatory change was an honest mistake. I ask rhetorically, if it were a deliberate lie, why expose the lie almost immediately? And in any event, no credible reason has ever been put forward why it would have been a lie. The case theory that the lie was told to secure withdrawal of note holders' funds makes no sense. A withdrawal would have been necessitated by the UCITS regulations in any event, whether or not the problem regulation was recent or long-standing. And even if it were a lie, which I don't for a moment accept, the suggestion that it is cogent evidence of a risk of dissipation is in my submission fanciful. A lie of this nature is much more likely to stem from embarrassment that the issue was not spotted sooner. Now, I don't condone such a lie, but the suggestion that a lie of that nature tells you that someone's poses a risk of dissipation in my submission is just wrong.
Mr. Collins doesn't say anywhere in his evidence, does he? I was embarrassed about this, so I told a little white lie.
No. He says it was an honest mistake. He had got the ideas somewhere. No, he
doesn't say somewhere in the letter. He says from 2 identified sources. Mr. Grant made quite a point of that.
Yes. Yes. But he doesn't, well, he clearly, either he was told the wrong thing, or he misremembered what he had been told, or miscommunicated what he had been told, or misunderstood what he had been told. He doesn't know where he got the idea from. He got an erroneous idea from somewhere. And my lord's quite right, he does not say anywhere that I told a little white lie. That is not his evidence. But I'm just testing the hypothesis put by Mr. Grant that it was a deliberate lie. I mean, what does that, even if it were a deliberate lie, what does that really tell one about someone's propensity to dissipate their assets? That's all I'm saying. As for the error in Mr. Gollitz's second witness statement about misreading an email which actually post-dated the communication to Mr. Taha, again, I say there's no reason to think that that's anything other than an honest mistake. Mr. Gollitz was being asked to reconstruct events 3 years previously at speed, having been served with some 1,700 pages of documents and a freezing order. He made a mistake and he corrected it with a subsequent witness statement. It's unfortunate, it shouldn't happen, but it does happen in civil litigation all the time. And I do say, my lords, that you're being invited to apply the most extreme double standards here. Multibank told Lavender J things that simply weren't true. For example, the fact that Mr. Gollitz wasn't a party to the PVI litigation. My learned friend would have your lordships deprecate us for raising that. But Mr. Gollitz made a mistake on the 3rd of December, only to communicate the true position the following day, and it has been turned into pillar number 1 of my learned friend's submissions on risk of dissipation. And respectfully, I suggest that this is the most incredible mountain made out of what is really quite a tiny molehill. Turning to the second pillar, the allegations in the Scottish proceedings. As to this, we rely, as I say, upon the judge's observations that this was not a case in which my clients were alleged to have engaged in behaviour in the nature of stealing or secreting assets. And it is right to take account of real weaknesses in the appellant's case. In fact, if your lordships are against us on the Ladd and Marshall application, and you are minded to have regard to the Scottish judgment, it's right to note that Lord Sanderson himself observes that there are real difficulties with the case. One can see that, I'm sorry, this is the last time I'll ask you to turn to the Ladd and Marshall bundle, but at the Ladd and Marshall bundle, tab 9, page 426.
Tab 9, page
426, my lord. Paragraph 49, around the second bullet hole punch. Well, I mean, perhaps if I can just invite my lords to read from the start of paragraph 49 to just beneath the second hole punch.
Do we know what a procedural debate is?
It's not in evidence, my lord. Wait. I'm sure we can find out, my lord, if you'd like to find out.
Well, perhaps it goes to Mr. Calvin's point that Scotland is, they speak a foreign language there.
It is a different system, my lord.
Well, isn't it to do with, well, precisely what it is isn't clear, but if one reads the whole thing, I think what he's got in mind is that at some later stage in the proceedings, there will be a more detailed examination of
Okay.
the merits, short of a trial.
Yes, well, he contrasts it with proof and a judgment. So,
Yeah.
and, I mean, this, I hasten to say, is guesswork. But
Yeah.
Yeah, I mean, your real point is that he's saying there are clear difficulties with the merits of the
Exactly.
case, and it's all have to be decided at some later stage.
yes,
Yeah.
yeah, and it goes no further than that. But if I say that there are weaknesses in the case against us, and if you're minded to take into account the views of the Scottish court, one should have regard to the fact that the Scottish court thinks so too. That's as far as I take the point. My multi-bank's claim relies upon the VDHI proceedings being the product of fraud, but I say they have not pointed to particular allegations in the VDHI
This is
proceedings.
the second pillar, is it?
No, we're still on the second pillar, my lord, yes. We say they've not pointed to the particular allegations in the VDHI proceedings which are said to have been made dishonestly, and in our submission it's difficult for them to do so, because those proceedings are founded upon documents and transcripts, the existence and terms of which are not in dispute. As to the fraud which is said to have been perpetrated on the courts of Luxembourg, Multibank's case is that Mr. Ford and Mr. Gollitz conspired with Mr. Smith to have that case issued on a false basis. But despite having free range over all of Mr. Ford's emails, documents, they are unable to point to a single email which clearly shows that Mr. Gollitz had foreknowledge of the contents of the Luxembourg summons. And such evidence as there is that there's been a conspiracy to procure false evidence from Mr. Smith, I say, must confront the fact that VDHI makes no use of those allegations in the BVI. As we asked in our skeleton, if this were a conspiracy to suborn Mr. Smith, why not use the suborned evidence?
Sorry, say that again.
The allegation made against us in Scotland is that we have conspired to procure false evidence from Mr. Smith. But that, as allegedly reflected in the Luxembourg summons, but those allegations are not reflected in the BVI proceedings. If the BVI proceedings are the subject of the same conspiracy, it's odd to suborn a witness and then accuse that witness of being implicated in a fraud. I mean, of course, it's not my client doing so, it's VDHI making those allegations against Mr. Smith. Pillars 3 and 4 were what Mr. Grant referred to as multiple untruths in the Ladd and Marshall evidence and in relation to my client's interest in CSN. Mr. Calthorne addressed those in respect to the Ladd and Marshall application, so I'm not going to cover that ground again. I'm about to move on to a new subject. It won't be very long at all, but
We will do that at 2 o'clock.
Court rise if able.